Hi, I'm Avalon Paul. I am one of the senior immigration attorneys here at Manifest Law. Now, unless you've been living under a rock, you probably heard the most recent news concerning H-1B visas from President Trump last week, Friday. Today, Monday, September 22nd, we are here to give you the latest updates as it relates to the H-1B petitions, the new fee increase, and answer all of the questions you have. We've been getting a lot of questions for H-1B visas and what it means when someone wants to change their status. So when an individual is in America on a non-immigrant visa, they have the option to change their status. So a change of status petition occurs when a non-immigrant wants to change their visa classification from one non-immigrant visa classification to another non-immigrant visa classification without leaving the United States of America. That's the key. So if you want to apply for a change of status petition, you do not need to leave America. However, there are some key factors to keep in mind when it comes to applying properly for a change of status. You may also hear in your research and online something called an extension of status, which is slightly different. But an extension of status says when you apply for this, you're keeping the same visa classification you have, just applying for more time. So now let's talk about how to actually apply for a change of status petition and not be denied. So there are some key requirements that you must keep in mind when applying for a change of status petition. Number one, you must be in lawful status. You must have a valid entry from when you entered America, and that status must not have expired. Number two, in applying for a change of status petition, you must make sure that you are applying before your current status expires. Why? Because if you apply after your current status expires, you will have fallen out of status and you are now going to start accruing unlawful presence, which is a very big no-no, and we really want to avoid that. Third, you must be eligible to apply for the new status you're seeking. Some people are not qualified or they're not eligible for the new status. And so in order to really ascertain and properly vet your eligibility, it is important to reach out to an immigration attorney so that you can properly vet whether or not you are qualified or eligible to apply for the new visa status you are looking to change over to. The fourth part you must really keep in mind is that you have maintained lawful status. Sometimes people tend to fall out of status unknowingly because they may have left the country or they did not fulfill all of the requirements in order to maintain their non-immigrant visa status. So please, in analyzing your eligibility and making sure that you are actually qualified to apply for the new non-immigrant visa status you're looking to apply to, make sure you have maintained the current status that you currently hold in your non-immigrant visa. Now, here's the thing to keep in mind. It's a very good question to ask whether or not USCIS approves every visa petition that comes their way. And the answer, to be frank, is no. Why? Because some people don't apply properly. They don't meet the proper eligibility criteria that this particular visa they want to change their status to requires. And so when it comes to applying, understand it is always up to the discretion of USCIS as to whether or not they're going to approve your visa classification change. And this is why this is not the time to try to do it yourself. Maybe try to apply on your own. You need an experienced immigration attorney who is going to help you, who's going to properly vet you and provide you with the best possible guidance you can have. And that is what Manifest Law will provide you with. Finally, don't forget that there are new fees and the fees are always changing. You do not want to run the risk or take any chances in applying for a petition, especially if you're close to the current expiration date for your current visa and submitting the wrong fees. Submitting the wrong fees will cause a big delay in your visa application being approved. So this is a nutshell of what it means to change your status. We've been seeing many questions on all of our platforms about OPT and changing status from F-1 to OPT. But here's the thing. You're not changing your status from F-1 to OPT. Let's take it a step further. OPT stands for Optional Practical Training. This is when a person who is currently in valid F-1 status is now applying for their OPT, or optional practical training. What this means is that they are now applying to add valid work authorization to their currently held F-1 status. And this will allow them to work while they are in the United States of America. Remember, if you are a student and you have valid F-1 status, you're not allowed to work. You come to America, you have all of your financials in place, and you're supposed to be here to study your particular field of interest. And you come in with enough finances to cover room, board, tuition, and your living expenses while you are here. Obtaining OPT, or optional practical training, is the part that allows you to have work authorization so that you can then go and start working for a company in your field of interest, or the industry, the area that you've been studying in while you have been on valid F-1 status. So how does this affect you, and how does the news on Friday affect you being a student who now has OPT? Because the big question is my employer going to have to pay this $100,000 fee when it comes to me applying for OPT? And the answer is no. When you are getting your OPT, you're not changing your status. You're simply adding work authorization. So the news that came out on Friday does not affect you. So if you are a student and you've been maintaining your valid F-1 status, and the long and short of it is, this will not affect you, even when you are applying for your work permit so that you can complete OPT. But students, do keep in mind, there has been some chatter about wanting to limit how long a student is going to be able to have valid F-1 status. As of right now, most students on their I-94, they are allowed to maintain F-1 status for the duration of status, or DS. And that's what you will see printed on your I-94. But there has been some talks with the current administration about wanting to limit the validity period for you on your F-1 status for the period of the length of the program. So if you're studying for your bachelor's, for example, and your program is 4 years, then there's going to be a sharp cutoff date for when your validity period ends. That's really what students have to be mindful of if that change is actualized. But this new fee increase will not affect you if you're now applying for OPT while you've been maintaining valid F-1 status.